We are live.
Good morning. It is February 25th in Senate Judiciary. We have Kim McManus here to talk about S-203. And floor is yours.
Thank you. For the record, Kim McManus with the Department of State's Attorneys and Sheriffs. Bill S-203 is looking to solve a language issue that came up last year out of an entry order in one of our superior courts, where the reading of any second or subsequent offense of a DUI, that the enhancement required a conviction of the violation, and the reading that way versus the actual violation created two issues. One was potentially an argument that you couldn't charge a second offense without actually having two convictions previous to that next event. That's one issue. The second issue was, you likely all recall that there's a 20-year look back when being able to have a sentence enhancement for a second, third, fourth. And one issue was raised out of that ruling was if you have a DUI in 2000, January 1st, 2000, and then you have a second offense in December 31st, 2019, and that's when the offense occurs, the violation. We believe the legislature wishes for that to be charged as a second offense. If the conviction for that offense didn't happen for another 2 years,
On the 2019.
Right, that second offense in 2019, if say it took a year or two to work its way to conviction, you didn't resolve the case till 21, we're outside of that 20-year period. The question was raised, could that impact the ability to have that as a second offense? And
then that would put the 2000 conviction outside of
the 20-year period. So the suggestion was, so the wording currently, and I'll just focus on second offense, and we essentially just replicate the language for third and fourth. The current language is a person convicted of violating, and then it references the driving under the influence statute, 1201. And the suggestion is a person who violates section 1201, so that we're focused on the date of the offense when we're looking at the charging, and then looking at the ability to have the conviction within that 20-year period.
So the date of the offense is the controlling date for this, as long as there's a conviction?
Correct.
Okay.
So it would go from past conviction to new violation, as far as that 20-year look back, and then it also wouldn't create no confusion about charging a second or third. You don't need the conviction to be able to charge it as a second or third offense if there's been a previous conviction.
Wait, can you say that last sentence?
This one, I know, this one, so, well, I'll use me as an example because I do not like giving senators charges. So I have a DUI conviction from 2010, and then I'm charged with another DUI 5 years later. We believe the intention of the legislature is that could be charged as a second offense. I have a previous conviction of a DUI. This is now my second allegation within the period. A very strict reading of the current language, folks can get to a place where they're saying, oh no, you can't charge that until you have the second conviction, which, exactly.
You can't charge the second offense unless you have a second conviction.
That's the strict reading of a person convicted of violating the section.
Okay.
So, and again, this is a judge provided this analysis, and it's not a widespread analysis, but it was raised, and so we just want to correct. And again, we do not believe that was the intention of the legislature.
Creates like the loop. You can't. It essentially makes it, if you read it that way, that you can't charge it, because if you can't charge it until it's convicted, it's
Exactly, or what it would create in reality is that I would really need to be on my third offense to be charged with a second offense,
Yeah.
because then I'd have two convictions of violating and then I've offended again. So it would create, and again, we do not think that's what the legislature intended. And so with this language, we correct both issues. That one that's a bit outside, and again, not how we believe most are interpreting statute, and then the look back period.
I think that makes it more clear.
I just have one quick question. So, Kim, you got your DUI conviction in 2005, you're charged with another DUI, second offense. So, 5 years and 1 week later, you're picked up again and charged now with DUI third offense. If the second offense is acquitted, and this individual actually was brought to a facility, because the third is a felony, but the second was acquitted, where does that leave the officers involved as far as, at the time, it appears as though that they could, may, but let's say they were in the second offense, they were acquitted.
So you still would need to say for that, so if you had a third allegation, right, so that's the moment of violation, you would look back on the record, there'd only be, if someone was acquitted of that second one, there'd only be one conviction.
No, what I'm saying, 5 years and 1 week later, okay, this 7 days after the individual was alleged to have been driving while under the influence, they're picked up again, let's say, by the same officer. He or she has information that, yeah, they were processed for DUI second. Now this is their DUI third.
But if the DUI second was, it's reached disposition, there's been an acquittal, or no, it's still pending?
No, it's still 7 days later, it's still pending.
Oh, sorry, I didn't, okay, so, right, so we have one conviction.
Yep.
And then you have, one charge for
Within
DUI
20
two.
years.
Mhm.
And then
And
7
then
days later, picked
right,
up again.
so this is another issue that was raised by our TSRP, and we didn't know whether we wanted to bring this up now, so that week later, that officer right now would charge that as another second offense.
Another second.
Yes, because again, there's only a conviction for one, previous one. There's a pending charge,
Yeah.
and there's an allegation, but there's no resolution to that second offense. So that is an issue that we come across. Someone could get multiple violations in a row, but the enhancement is connected to a previous conviction. And it is an issue, Senator Norris, and it's a question of whether if we want to tackle that issue at this time as well, but that is an issue out there.
I don't want to tackle any more issues.
No, but it is an issue raised, but it does get more complicated, because again, those are allegations until they're disposed of one way or another. Whether you want to be able to enhance those later, that's a question for you all, but that's a much more complicated conversation.
So, is it safe to say you support this bill as introduced?
The-
Or do you have any language?
Nope, nope, this, I believe, we had very similar language suggested, and so this satisfies, what we were looking for, and I just had a note from our, traffic safety resource prosecutors that the language introducing the bill, that's making it very clear, what, that you want these offenses to be connected to the violation date within that 20 years. If that language is able to be in the, I always forget how it works with the, what is it called?
Findings?
No, when you release the legislation, you're able to put in, I'll think of it and I'll write it to you because I'm.
Intent?
Yes.
Legislative intent?
Yes, the legislative intent, sorry.
Yeah,
Right.
no worries.
Yes, just to make it very clear.
Yeah.
And again, this is something that most interpret the way we believe you meant to have it, but then this just clears it up.
Committee, any questions? Okay. Well, thank you. Appreciate it. I had a feeling this was going to take a long time.
No, I saw the hour schedule and I was like, oh no.
Yeah. So later on in the day, we've got 186 up for discussion and a possible vote. That was the bill we last heard from Valeria on. It was the plea agreements for juveniles and do you folks remember that bill?
I must not have been here.
Are we, what are the recommendations?
Oh, yeah, I know what you're talking about.
Yeah.
In criminal court, they can plead to a lesser charge with that, how it comes back
Yes.
to criminal court.
Yeah.
Okay.
I know Valerio raised some suggestions that it gets sent to that other working group to see if they have suggestions. I'm wondering if that's how the committee also feels about the bill, or if there are others we should hear from regarding the bill. And if not, then we can, well, yeah, any thoughts on that bill?
Presently, as the bill stands, I don't have a problem with it, but I don't have a problem with referring it to this special committee if the committee here seems it necessary, so either way, I'm 50-50 on it.
Ready? I think I agree with Bob.
You sound so
That-
surprised.
Either thing is fine, either.
At this point, I'm sort of not heavily compelled in either direction. You know, I'm fine sending it to a working group if they would have and I think if they do have other suggestions and there's broader things, like that makes sense to me. I imagine this is not an issue that comes up terribly frequently. And
Once
so,
in a while, yeah.
so it doesn't feel incredibly pressing that it has to be changed, you know what I mean? So if Matt or Marshall or whoever raised that in their office feels that that's what we should do, then I'm fine with that.
So I do have a question on that.
Yeah.
As many of you are aware, some of us may not be back next year. This report was suggested to be submitted by November or whatever else, so does the bill still go to the floor as is, pending the report from this special group, or does it get hung on the wall we wait? What happens to the bill?
I think Matt was suggesting an alternate path from the bill.
Okay.
In other words, the bill would die on the wall, but that working group would take it and then bring it back to us next year.
Because we can't bind a future legislature, so
Right.
we couldn't say you have to do this.
I also know there was some conversation about making an amendment to make the charge related to that nexus of conduct. I remember that as well. And
Yes.
I think I asked Eric to make that draft. So could you actually please reach out to Eric and see if he might be able to come in? We got 45 minutes, so may as well.
Wow.
Right, fill it in.
Not much gonna be.
186, please.
So that was the one where if someone said, well, aggravated assault, felony aggravated assault, if they pled down to a simple assault versus pleading down to a DC or an unlawful mischief, whatever else, there was concerns as to keeping it within the confines of what the actual charge was.
Keeping it within the confines of the same case, so like the nexus of conduct, in other words, you know, yeah, let's say you trespassed to commit an aggravated assault, that trespass is still in that nexus of conduct, but let's say you got that docket, but then a month later you have a completely separate docket and they want to do a universal plea deal that says, okay, the second docket and the first one, we'll combine it into one plea agreement, and that could be where things get hung up. If they're trying to amend things to the other docket that aren't related at all to the first one, if that makes sense.
So we're back at 10?
Well, we're gonna see if Eric can come down. We can take a 10-minute break. We can go off for